man, tech extraordinaire. But thank you so much to Hosea Baskin for joining us this evening and for leading this wonderful workshop. This is really helpful.
It's a pleasure to be here, to be talking about estate planning, which is what I do. I'm a trust and estate lawyer here in Northampton. Um, and there's really sort of two areas that I thought we would cover, which are sort of the two basic areas that are generally included within the broader idea of estate planning. And one is all about estates and one has nothing to do with estates. So first, I thought we'd start with the one that has nothing to do with estates, which is planning for incapacity. And in certain ways, it's even more important than estate planning. Our friends in the State House have done a really good job of covering for us if we never get around to writing a will. There's a whole set of rules about what happens to your stuff after you die if you don't have a will. And it all happens pretty simply. Like, it's better to have a will, but it's not essential. For incapacity, it's really important to have a healthcare proxy and a power of attorney, because if you don't, and then you become incapacitated, whoever's going to be functioning as your guardian or custodian is going to end up in probate court having to petition to become, to take on those roles. It's a stressful pain of an experience that is really easily avoided by putting these pretty simple documents in place. So I thought that would be a good place to start. So there's two documents that together cover, I'm sorry, I should back up for a second. I just leapt right in. I'm going to talk about incapacity, and then I'll break and take questions on that, and then we'll talk about estate planning, and then we'll do more questions at the end. And I should also say, I'm a trust and estate lawyer. I spend my days not just thinking about all the terrible things that can happen, but all the different orders and sequences in which those terrible things can happen. So I'm used to thinking and talking about this stuff all the time. It's not easy stuff. It's dealing with, planning for painful eventualities. And so there's quite likely that something will hit you weird at some point in the conversation. If at any point you need to take a moment, take a break, feel free to step out, catch your breath. It's all being recorded. You can watch it later, catch up on the parts you missed. So look after yourselves.
Yeah. I was wondering if you could define the term incapacity. What incapacitates a person?
Sure. So in classic lawyer fashion, I will say that depends. We don't have a single across the board universal definition of incapacity. I was just talking about this with somebody today, that incapacity means different things in different contexts, that the amount of capacity you need to have to make a medical decision for yourself is different than the capacity you need to write a will, and that's different than the capacity you need to sign a contract. And capacity is determined at that particular moment because it's not linear. It can fluctuate. People can have better days and worse days, and so.
And it's also difficult to define someone's incapacity.
Yes. So it's to some degree situational. Whether somebody is able to do the things in a particular sphere that they need to be able to do independently and on their own? Are they able to, um, manage their finances, manage their checkbook, or are they able to assess the information and make a medical decision? And so it really varies from situation to situation. And sometimes it's very clear that someone is on one side of the capacity line or on the other side of the capacity line. But the gray zone is actually pretty sizable. And um, sometimes it comes down to a doctor's determination, but it's it can be trickier than you would think to determine.
And you're making a distinction between incapacity and the legal definition of competence and incompetence?
I'm using them basically interchangeably.
Okay.
Yeah, so the most important thing you can do for dealing with incapacity or competency issues is to decide who you want to have making decisions on your behalf and managing your affairs at the point where you're no longer able to do those things. And um, so these two documents work hand in hand. Let me start with the healthcare proxy. Um, it's conceptually, it's a very simple document, and actually they tend to be pretty short. It basically says, if I'm not able to make medical decisions for myself, this is the person who I want to make medical decisions on my behalf, and that person is entitled to access to all the medical information that they will need in order to be able to make those decisions. The important thing to understand about a healthcare proxy is that the person you're naming, their responsibility is not to do what they think is in your best interest. Their job is to do what you would have done, make the decision you would have made if you were able to make it yourself. So they're supposed to step into your shoes. If they can't work out what you would have done, then as a fallback, they assess what is in your best interest. But their first job is to make the decision that you would have made if you were able to make it yourself. And what that means is that choosing somebody, asking their permission, putting them on the document, signing the document, that's all really important. But it's only half of the matter that needs to be dealt with. The other half is the conversation with the person you've named to make sure that they know and understand what you want, what your desires are in a given situation. And it's hard to cover the whole range of possible scenarios, but to communicate to them your values, your belief about medical interventions or end-of-life issues, or it's not going to be a conversation. It's going to be a series of conversations, and they're not necessarily easy conversations, but they're really important.
There used to be a form, but I can't seem to locate it anymore. It's not the most and it's not the post. It's this form that used to have scenarios. If this, then that. And it would be sort of spelled out. Does that form still exist anymore?
Yeah, it's sometimes called an advance directive or a living will.
Yeah.
It's actually a form that Massachusetts has decided not to put its faith in. We still have those forms and you can fill one out, but Massachusetts law puts a healthcare proxy where you're naming a person to make decisions on your behalf ahead of an advance directive where you're spelling out what you want to have happen or not happen, partly because an advance directive is a very blunt instrument. You know, medical scenarios are incredibly complex. You can have all kinds of things going on at the same time. Having a two-page form with a bunch of checkboxes is usually not that helpful in those scenarios when, you know, if there's do you want a ventilator to be used? Yes or no? To be used for 3 days or to be used for the rest of my life? They're very different questions, and it's hard to capture that sort of granularity in an advance directive.
But I would imagine it's a good way to have a conversation.
That's what I,
It can be a really good conversation starter.
That's what I was
Yeah.
thinking, because I'm
And-
a proxy for a bunch of people, and I want them to fill that out, so I
Yeah.
remember who's who.
Yeah.
And what's what.
So it can be a helpful tool to inform those conversations, but I would say it's a useful tool in that way, but it's not a great thing to rely on for actual decision making.
So they still exist, though.
They
but I
do still
see.
exist. If you were to search for, sometimes they're referred to as a living will, sometimes an advance directive. There's also a good resource. It's called 5 Wishes. That is a website that has, it sort of is set up to facilitate these kinds of conversations. 5 Wishes, I believe, is what it's called. You mentioned MOLSTs and POLSTs.
Yeah.
Let me just touch on those for a second because they are related to healthcare proxies but different. A healthcare proxy is a legal document that says if I can't make decisions, who's going to make them on my behalf. A MOLST or a POLST, it's a medical order for life-sustaining treatment or a physician's order for life-sustaining treatment. Different states use different versions of the acronym. It is a 2-page form, very much like a living will, but it's actually something that you do in conjunction with your doctor. And it's a medical order rather than a legal document. And it does say, do this or don't do that. It's something that you probably don't want to put in place until you're facing a serious or chronic, life-threatening health situation. Its main purpose, it's on bright pink paper, you put it on the fridge, and its purpose is that if an ambulance crew, if EMTs come to the house, part of their protocol is to look on the fridge for this pink piece of paper and to follow its instructions. If it says no CPR, they won't do CPR. If it says no ventilator, they won't do a ventilator. And you can be waving a healthcare proxy at the ambulance crew and they will ignore you because it's not their job to listen to what people in the household have to say. It's their job to follow their protocol. But part of the protocol is to check for a MOLST or a POLST and to do what it says. So if you're at the point where there are medical procedures that you would not want to have done in that kind of a scenario with an ambulance crew, then it's really important to talk to your doctor about a MOLST or a POLST. It's an important part of the puzzle.
Can you spell out that acronym and what it stands for?
Sure. MOLST, Medical Order for Life-Sustaining Treatment, or POLST, which is Physician's Order for Life-Sustaining Treatment. And
I think it's okay.
they are, I forget which one we use in
We use
Massachusetts.
Pulse now, they got rid of those.
Yeah. There may be slight differences between them, but conceptually they're the same.
Does it have to be signed by?
It has to be signed by a doctor. Yeah, you sign it and your doctor signs it. And
And if you're not competent, it's also.
it can be signed by the person who holds your healthcare proxy or is your guardian. Yeah. So,
Yeah.
sure.
So did it take the place of the advanced directive?
No, it's sort of different. An advance directive is less a sort of in the moment form. The POLST or MOLST has this very specific purpose for EMTs to consult when they're making a house call. Whereas an advance directive is a more general thing if you're in the hospital and you're not able to make your own decisions and your family members are trying to decide what to do. An advance directive is a legal document that you've completed that says do this or don't do that. Whereas a healthcare proxy is a legal document that says listen to this person, they know what to do. They're sort of overlapping. Most states have sort of embraced both. Massachusetts is a little unusual in that we won't ignore an advance directive, but we will give primacy to a healthcare proxy that names a person to make decisions. I think we put our faith more in people than in checklists, which I think the legislature actually got that one right. I think it's a good call. So healthcare proxy covers medical decisions. Its sibling is the power of attorney. Power of attorney is a much broader document. It basically covers everything other than medical decisions. Everything from financial decisions, accessing a bank account, paying the mortgage, paying the bills, dealing with retirement accounts, but also non-financial. It could be running a business. Non-financial matters, looking after pets, making decisions about somebody's living situation if they're not able to make those decisions for themselves. So it's a much broader document. The person you name in that document is called your attorney in fact, not to be confused with an attorney at law. That's why it's called a power of attorney. You're making somebody your attorney in fact, giving them the power to make these decisions for you. The kind of power of attorney that you want is a durable power of attorney. And a durable power of attorney is one that is in effect not just, you can sign a power of attorney. Let's say you're, going away for 6 months to somewhere far away, and while you're gone, your house is being sold, and you want somebody to be able to sign the legal documents for you without having to FedEx them back and forth to Uzbekistan or wherever you're going to be hanging out. And you can sign a power of attorney that gives somebody the power to sign those legal documents on your behalf. A traditional power of attorney is only in effect while you are competent. The moment you become incompetent or incapacitated, a traditional power of attorney ceases to function. There's also what we call a durable power of attorney. And a durable power of attorney is the kind that you want because it stays in effect even after you lose incapacity. And that, for most people, is actually the moment at which they want to have somebody who can manage their finances or other things for them. Massachusetts has not, some states have actually sort of come up with a standard power of attorney form. Massachusetts is not. You might well find one online, but I wouldn't recommend it. It's something to talk to a lawyer about. They will have a power of attorney. Basically, it's not something that gets tweaked a lot from client to client. You drop in the names and print it out. It's a standard form. But each lawyer will tend to have their own version that they've worked out over time that for whatever reason they like the way theirs is.
Is it different than guardianship when you go to court?
Yes, it is. It's actually a healthcare proxy. The line between guardianship and conservatorship is slightly different than the line between a healthcare proxy and a power of attorney. When you go to court, family court, to get somebody appointed as a guardian or a conservator. Um, a guardian is responsible for things having to do with somebody's sort of personhood, their medical, their living situation, their things to do with their living, their living arrangements. Um, whereas a conservatorship has to do with financial matters. Um, and some people may need a guardianship but not a conservatorship, or vice versa, depending on their particular level of capacity. I guess a power of attorney is more like a conservatorship than a guardianship, as it mostly has to do with financial matters, but it also covers things to do with non-financial aspects of living that are non-medical, not specifically medical. The two documents are really important. They work together really well, and they're very simple to put into place. If I had one soapbox to get up and yell and scream about, everybody should have a healthcare proxy and a power of attorney. The moment you turn 18, you should get one. If you have, children or young friends, they should have a healthcare proxy and a power of attorney. Even if they don't have two nickels to rub together and they're not leaving an estate, this is a piece of planning that everybody should do. It's simple, it's quick, it's easy, and in the event of incapacity, it makes life infinitely easier. No,
I'm so sorry.
yeah.
Is it possible legally to appoint multiple individuals for these roles, or is it you appoint alternates?
You can both. You can name people to act together, and you can also name backups. It's always good to name backups. You never know when somebody's going to be unavailable. And in terms of naming multiples, I tend to think it works better for a healthcare proxy, for a power of attorney than a healthcare proxy. With medical decisions, I generally suggest name somebody and instruct them to consult with and ideally achieve consensus with everybody who is involved. But ultimately, people don't always agree. And having somebody whose ultimate responsibility it is to make the decision, who you trust, particularly in the medical sphere, I think is really important. You don't want to get a situation where, there are two children at loggerheads about how to proceed with a parent's medical treatments. It's I'll sometimes say, if you don't want to play favorites, name one as the healthcare proxy and the other as the power of attorney. But ultimately, you need to pick the person who you really trust to make decisions in a difficult scenario. It's the overall term for all of these different positions is fiduciary positions, and the Latin root of fiduciary is a fiduciary is a person of trust. It's you need to name somebody you trust in these positions. I think that covers the basic sum total of my wisdom on the subject of incapacity planning. But let's take a break for a second. And are there other questions on this zone before we move into estates?
If you go to, or when you go to a lawyer, you should go to a lawyer to do both of those documents, healthcare proxy and maybe a power of attorney. And all the decisions, I guess, need to be made obviously prior to that.
Yep. I mean, generally, part of what a lawyer will do is walk you through the decisions that need to be made. Explain these different fiduciary positions, the healthcare proxy, power of attorney, and we'll talk in a minute about executors of wills or trustees. They'll explain the differences in these positions, and you can talk with them about who the options might be. And it can be a family member, a friend. There's no requirements other than that that person be 18 and actually be not incapacitated themselves, preferably. So,
I don't want to jump ahead, but I was just curious if you would define why someone would choose a well over a list.
we'll get to that in a second. Okay.
Yep.
Anything else on the first half, or should we move to the second half? Let's move to the second half.
I did want to jump in. We have bottles of water, if anyone would like any. And there's also bathrooms at either end of the hallway. Just a little housekeeping that I didn't get to earlier.
Sip of tea break.
Anyone like any water or anything?
Not right now, but thank you.
Okay. Estate planning. What happens to our stuff after we die? And as I said before, if you don't write a will, our friends up on Beacon Hill have set out a sort of set of rules for what happens. They've said, if you have a spouse and you don't have kids with anybody other than that spouse, then the spouse gets everything. If you have a spouse and you have kids by somebody else, then the spouse gets some and the kids get some. If you don't have a spouse but you have kids, the kids get it. No spouse, no kids, it goes to your parents. No spouse, no kids, no parents, it goes to your siblings. No spouse, no kids, no parents, no siblings, goes to your nieces and nephews. No nieces and nephews, cousins, and it goes all the way out until third cousins. If you don't have anybody closer than a fourth cousin, then the Commonwealth of Massachusetts gets whatever you leave behind if you don't have a will. What they tried to do is sort of think about what would your generic average person want to have happen. And, you know, for most people, you're going to leave stuff to your spouse or your kids. You know, it's sort of, but it's better to do a will because by writing a will, you're actually making an affirmative statement of here's what I want to have happen. It takes any question out of the matter. And it also, as well as saying who gets your stuff, who your beneficiaries are, beneficiaries of your estate. It also gives you the chance to say, this is the person that I would like to be, use a bunch of different terms here, either my executor, which is also sometimes called my personal representative. And that's the person whose job it is to clean things up after you're gone. So let's go in a slightly different direction for a moment. And let me talk for a minute about the probate process. What happens to an estate after somebody dies? Yeah.
What if you're not married, you don't have a spouse, but you have a partner?
You need a will. Legally, in the eyes of the state, a partner to whom you are not married is a random human being. It's yeah.
One can hope.
But you know, so if you have a partner and no will, your partner's out of luck. If you have a partner and a will, and your will leaves everything to your partner, then everything's hunky-dory. This is why wills can be important. Or, you know, if you can't stand your kids but really love your nephew and you want everything to go to your nephew, you better have a will, because like if you want anything that's out of the ordinary, the way you do that is with the will. Okay, back to probate, a word that probably most people have heard and nobody knows what it actually means. Probate is the process after somebody dies of administering their estate. What is administering their estate? It basically means gathering together all of their assets, paying off any creditors, anybody who they owed money to at the time of their death, which could be credit card bills, utilities, medical expenses, and any of the, any loans that they had taken out from anybody. Once all of those creditors are paid, the assets that are left behind are divided up amongst the beneficiaries, and that would either be, if they left a will, who the will says the beneficiaries are, or if they didn't leave a will, that whole list of relatives that I just went through and will not repeat again. And so conceptually, it's fairly simple. The probate process usually takes about a year, which is generally a flurry of activity in the first like 3 months, and then sitting around and waiting for 9 months, and then finishing things up after a year has passed. Why a year? Part of what probate does is a balancing of the interests of the creditors and the interests of the beneficiaries. If you lend somebody, $10,000 and then they die, you shouldn't be out of luck. You should be able to, get the money that you lent to them back. But if somebody is a beneficiary of an estate, they shouldn't have to wait forever to get the proceeds of the estate. So we've decided that a year is a reasonable period of time for anybody who is owed money by somebody who has died to stand up and say, hey, the decedent owed me 10 grand. You've got a year, if somebody's died and they owe you money, you've got a year to stand up and say that. If you show up after a year and a day and say, hey, they owed me 10 grand, you're out of luck. And so generally there aren't people coming out of the woodwork who say, hey, they owe me 10 grand. It's usually credit card bills and medical bills, and the executor has a pretty good handle on what the expenses are. But they can't know for sure until a year has passed because we've set this year deadline. So usually what an executor will do is their first task is to go to the probate court, which is down at the end of Pleasant Street, just under the highway, probate and family court, nice new building, and to file a petition with the court that says, this person has died, I'd like the court to appoint me as their executor. Here's a copy of the will if there was one, or here's a statement that says there's no will if there isn't. I've notified all of the closest relatives, and I've also let Mass Health know that the person has died because that's a requirement. And the probate court will look at that petition, and if all the paperwork's in order, they will stamp it, and at that point, the person who made the petition to become the executor is now the executor, and they have the legal authority to gather together the assets, pay off the debts, and start making payments to the beneficiaries as the will directs. Usually a responsible executor will keep a little money held back until that year deadline has passed in case anything surprising happens. And after a year, they will take whatever's left, pay that out to the beneficiaries, and at that point, the process of administering the estate is done. If there's real estate, part of the executor's job may be to sell the real estate. If um, if there are tax returns that need to be filed, because yes, our friends at the Department of Revenue and the IRS still want you to file a tax return for the part of the year that you were alive. It's the executor's job to file those returns. So there's a bunch of tasks. It's generally about a year process. It can last longer for a complicated estate, but for most estates, it's a year. So that's sort of the process of administering an estate, and that process is called the probate process. We talk about wills next, but I'm guessing there may be a question or two on this subject. So
are there checks and balances in place if an executor hadn't been named prior to the death? How do you prevent a bad actor from showing up and misbehaving?
If one of the reasons to have a will is so that you can name an executor. If you didn't leave a will, then again, there's a set of rules as to who gets to be the executor. If there's a spouse, the spouse has the first right to serve as executor. If
the spouse was like a abusive, alcoholic bad guy,
then that's a really important reason to write a will. It's a situation where the law doesn't really. Another person who has an interest in the estate. If there was a spouse and kids, and they were, and the kids felt that the spouse would be an inappropriate executor, part of the reason you make a petition to the probate court is that all interested parties have to be informed of the petition. And so one of the kids or all of the kids could contest the appointment of the spouse as the executor. And at that point, the probate court would have a hearing and would determine who should serve as the executor. But there's an order. It would be the spouse and then the kids and then whoever would be next in line to be the beneficiaries of the estate. So there is, particularly if things are contested, there's a lot of oversight from the court. There used to be a lot more oversight from the court in all probate situations, and that made probate much more long and complicated and expensive, and led to people coming up with all these ways to avoid probate. And the legislature eventually, in their infinite wisdom, said, if people are going to this much trouble to avoid probate, maybe there's something wrong with it. And so a few years ago, they reformed the probate process pretty drastically. And so for a simple estate, which is not contested in any way, going through probate isn't nearly as much of a hassle as it was a generation ago.
So it's been improved.
It's been improved drastically. Often you'll make that first petition to the court to get appointed as an executor, and that's the last the court hears from you. If all the beneficiaries are in agreement, you just go about administering the estate without oversight, and if there's no conflicts, you never go to court again.
And has probate court nationwide been revamped, or just in Massachusetts?
There's been a big nationwide movement to reform probate processes. I think that most but not all states have reformed their probate laws and have generally done it in similar ways, but of course, this being the US, we have 50 states, each has its own set of laws. Every state likes to do things slightly differently, and so every state has a slightly different approach.
Part of probate is
public information?
The documents, the probate petition that states who's seeking to be the executor, who the beneficiaries are, and if there's a will, that becomes a public document. And I'll touch on that in a minute because I want to loop back. I want to talk about wills for a moment, and then I want to talk about trusts. And one of the reasons why people use trusts is for exactly that reason about public versus private info. Gene, did you have a? No. Okay. So a will is the basic estate planning document. And again, conceptually, it's pretty simple. It's a document that says, here's who I would like to have clean up my mess after I'm gone. And if that mess is worth anything, here are the people who I would like to be the beneficiaries. So it's, yeah, there will be a bunch of extra bonus legalese in there because some of it required, some of it because that's just what lawyers do. Some of it actually very useful, and you'll be very happy your lawyer put it in there. But conceptually, it says, you know, this is the person I'm naming as my executor or my personal representative. If they're not able to serve, then this is the backup, or this is the second backup. It's quite common to name multiple people to act as co-executors, particularly if in a situation where the children are serving in that role. It's quite common to have kids serve together as co-executors, particularly if they get along well. If they don't get along well, then naming them as co-executors is probably a recipe for disaster. And the beneficiaries can be anybody you want them to be. Your children, your spouse, your siblings, your nieces, your nephews, your best friend from college, your neighbor, cancer connection. Just saying.
Not your dog.
Not your dog. You can set up a trust for your dog, but you can't leave money to your dog. And trusts for dogs are a fairly recent innovation. Yes. So anybody can be your beneficiary or beneficiaries in any proportions you want. You are not required to leave anything to anybody. The only person who has a right to any portion of your estate is your spouse. And a spouse has a right to part but not all of your estate. You can't completely write your spouse out of your will.
That's Massachusetts.
In Massachusetts, yes. It varies from state to state.
That's awful.
Yeah, you know, it's why divorce is important. You know, on the other hand, you know, if it would be pretty awful also to be married to somebody and then they die and you discover that they've written a will that leaves you nothing. So it's, yeah, there's possibility for awfulnly on either
Is
side.
there a de minimis amount, or is it?
It's a percentage. It's a percentage.
I love
Yeah.
them.
I'm a retired lawyer.
Yes.
Oh, and I was a probate paralegal, so
Oh,
I should tell you that.
Correct my errors, please.
That was a long time ago,
Yeah.
and not in this
Yes.
state.
So, I lost my thread there for a second.
Can't write your spouse out of your will.
Can't write your spouse out of your will. So, you know, will is conceptually a fairly simple document. It is, as we said, a public document. And so, let's see, there's two other things I want to talk about. One is non-probate assets, and then I'll talk about trusts for a minute. So any asset for which you can designate a beneficiary, so that could be a retirement account, an investment account, a life insurance policy, anything where you fill out a form and say this is the designated beneficiary. Um, those assets all pass to those designated beneficiaries outside of the probate process. They um, like skip around the outside, and um, so they're not subject to access from creditors in the same way. They just yep, go straight to whoever you named. So
Yeah, that's what it does.
no, that's just for if you have a retirement account or a pension or a life insurance policy or some bank accounts allow you to do this. Or um, if you own a house together with somebody and in the deed for the house it says that if you own it jointly with somebody else as opposed to owning it in common, um, the survivor automatically gets ownership of it. So those transfers all happen outside of the probate process. And so it's really important if you have any of those kinds of assets, and often people do have 401ks or IRAs or other kinds of retirement accounts. Often you were asked to fill out the beneficiary designation form when you set up the retirement account, which could have been 20 years ago. And you might have filled it out and not really thought about it. And so it's important to go back and check and make sure that who you named as the beneficiary of any of those assets is still who you want to have as the beneficiary.
Everything actually goes into a trust.
Yeah. So, all right, so let's talk about trusts. Trusts are one of those things that everybody has sort of a vague notion of what they are. But again, people often don't have, like, if you ask them, so define it, and they're like, yeah, it's kind of a thing. A trust is a legal arrangement for a particular asset or group of assets that splits responsibility for it. Usually, when you own something, like say a car, you control it and you benefit from it. What's it mean to control a car? You get to decide when to take it in for an oil change, whether you're going to get an inspection done or drive around with an out-of-date inspection sticker. If you want to paint it green with purple polka dots, you can. You control the car, right? You also get the benefit from it. If you want to hop in and drive to, Dunkin' or wherever and, get yourself an iced latte, you can because it's your car. You get the benefit of driving around in it. It takes you where you want to go. These two parts of ownership, control and benefit, are so sort of tied together that we don't even think of them as being separate from one another. We just think of that as being what it is to own something. You make the decisions, you get the perks. But they're actually different. Control and benefit are two sets of aspects of ownership. A trust is a legal arrangement where we separate out control and benefit, and we put control into the hands of one person or people or entity, and benefit into another. The person in control is called the trustee. The person who gets the benefit is the beneficiary, and that arrangement is a trust. Why the heck would we do something that weird? There are a few reasons. One is if the beneficiary is somebody who's not in a position to be able to look after the assets, whether it's because of capacity or could be issues with substance abuse or addiction or issues with gambling, say, or because they're a toddler and really getting 2-year-old to make investment decisions is generally a bad idea. So there are all these different situations where it makes sense to have one person get the benefit, but somebody else be sitting with the control. That arrangement is a trust. We sometimes use trusts in estate planning. They get used if the beneficiary is somebody where capacity is an issue. They can also be used if, as you raised, confidentiality is an issue, because a will is a public document. Anybody can go down to the probate court, the registry of probate, and pull up the will for anybody who has died and their will has been entered into probate. Sometimes you don't want people poking around in your business. And so you can have a will that says, I leave everything to the so-and-so trust. That trust is not a public document, it's a private document. The only people who have access to that document are the trustees and the beneficiaries. And so you raised the issue of abusive spouses before. Somebody who has an ex-spouse who they, had an abusive relationship, and they may want to shield that ex-spouse from being able to gain any knowledge or information about what's happening to their estate. That would be a situation where a trust could act as a really helpful information barrier, because they can pull up the will, and the will just leads them to a dead end. So trusts can be useful in a bunch of ways. They can also be useful for dealing with estate taxes, with larger estates sometimes. They get used in that way, or for passing things down through multiple generations. They can be used to hold, like, if a classic use is if there's like a family vacation home that's been in the family. I was just talking about with somebody who's a little cottage on a lake that's been in the family since 1890, and putting that into a trust is a way to hold it over time in a way that can work better than having ownership be sort of divided up amongst members of the family. They were also used a lot to avoid probate back when probate was a pain. One way you could avoid probate was you'd set up a trust while you're alive, put everything into the trust, and then when you die, you don't leave an estate because all your assets are held by the trust. So it was a way to avoid probate. As I said, people are doing that less now, now that they've reformed the probate process.
Is that what's called a sham trust?
A sham? No, it's usually called a living trust or a revocable trust. A sham trust? I don't know the term a sham trust. There were trusts that were used to shield information about real estate ownership. That were, what's the
They were
term?
called land trusts in some states.
They're land trusts in some states, or I remember when my brain was young and I could remember words. It is a nominee trust is the term that was a particular kind of trust that was used if you wanted to hide information about who owned real estate, because real estate is recorded at the Registry of Deeds. You could use a nominee trust to do that. We've now come up with new and more sophisticated ways to hide ownership, so we don't use nominee trusts nearly as much anymore, which is good because they were kind of a pain in the neck. So I think that covers.
And there could be tax, I mean, you sort of touched on tax planning.
Tax planning. So,
Yeah.
So with let me talk about estate taxes for a second. We do still have a federal estate tax. I believe this year the individual exemption is around $13.5 million. You get to pass that to your kids tax-free. If you're a couple, you get to pass 27 million tax-free.
Wow.
So
So all my friends are already doing
federal estate taxes are a fabulous problem to have.
Yeah.
I am actually, I've been practicing now for 6 years. I'm yet to have to deal with federal estate taxes. I guess if I was dealing on the Upper East,
Yeah.
in practice,
Back in the 70s when I
Yes.
did it, there were lots of federal
Yes.
state tax
Yeah.
returns.
The
They were
Fed,
so much
like,
different.
25 years ago, the federal estate tax limit was $675,000. And there were a lot more estates of over $675,000 in 1999 than there are estates worth more than 13.5 million today. So it's been pushed up from a tax that wealthy people paid to a tax that very wealthy people paid. Massachusetts has its own estate tax. For years, it was on estates of over 1 million. Last year, the legislature bumped it up to 2 million, so which was overdue, because 1 million was a smaller number than it used to be. It's a fairly, unlike the feds, where once you hit over 13.5 million for an individual or 27 for a couple, everything over that is taxed at 40%. So once you're up there, it's a hefty tax. Massachusetts has a graduated tax, so it starts at 2 million, and at that point the tax is, I think, somewhere around 6%, and then it slowly goes up and maxes out at about 10 million at about 18%. But it means that, for an estate that is worth just over 2 million, it's probably cheaper just to pay the tax than to pay the lawyer to go through all the jumping through hoops that it might take to avoid the tax. If an estate is worth 2.5 or 3 million, then you might want to do some tax planning and consult with an attorney about that. But yeah, most folks are not sitting on, like, most individuals are not sitting on more than 2 million. Most couples are not sitting on more than 4 million. So for most people, estate tax planning is not a major issue. If it is, consult with an attorney. People often worry about it, though. They know that there's an estate tax, but they don't know the details. So yeah. Questions?
I have a question about a trust. So if say there's a trust that someone has made someone else a beneficiary of, and they're still alive.
Yep.
But that the beneficiary didn't want to be
A beneficiary?
a beneficiary, but they went ahead and
Yep.
made the beneficiary anyway. So the beneficiaries had nothing to do with this trust. Who's responsible for paying the taxes on it?
The trustee, not the beneficiary, is responsible for the taxes. The beneficiary has no job but to cash the checks. The trustee is responsible for all of the work of administering the trust. The beneficiary is under no obligation to cash the checks. If somebody was made the beneficiary of a trust and they wanted nothing to do with it, they can disclaim their interest. They can say, nope, don't send me any checks. I'm not going to cash them. You cannot be required to be the beneficiary of a trust. Usually, it's a nice thing to be a beneficiary, but nobody can make you. It's like if somebody wants to give you a gift that you don't want to receive, they can't force you to receive a gift.
And years ago, there was what they called an inheritance tax.
Yes.
When you go way back, where the beneficiaries did pay it,
Yes.
but that's long gone.
Yes.
In different states.
Yeah.
What about those accepted or it's not
and then someone.
Yeah, so all of these positions, healthcare proxy, power of attorney, executor, trustee, one of the strange quirks in Massachusetts law is that you can name somebody in your documents in these positions without asking their permission.
I thought they had to sign off.
They, in some states they do, Massachusetts they don't. And it's good practice to get the people to sign off.
I
But
did the trust, they had
yeah.
to sign off.
A trustee has to actually, a trustee has to sign off.
Yeah.
A successor trustee doesn't. You can name somebody, like you could set up a trust where during your lifetime, you are the beneficiary and the trustee. After you die, somebody else becomes the trustee. You don't even have to tell them. But they are not obligated to take on that role. Just because you've named them doesn't actually create a responsibility, a legal responsibility that they take on those roles. So it's really good to check with whoever you're naming before you name them. Make sure they understand what the job entails and make sure that they're willing to take it on.
Did you say that you had a list of referral lawyers that you could?
I do, and I will leave that with the folks here at Cancer Connection. I think 4 different lawyers, 3 who are just, I think, very good general trust and estate attorneys, and then 1 who specializes more in elder law and mass health planning and that kind of stuff. And then also the Hampshire County Bar Association has a very good lawyer referral service, and I'll leave contact info for that too. They can always be reached and can hook you up with a good local attorney. Other questions? Sure.
Sorry for coming in late. We have set up trust for each of us and put most everything, like our house and et cetera, in the trust.
Yep.
But we still have some assets that are, I would call, outside of the trust because they existed long before the trust. And, so they're not in the trust.
Yep.
So they would go to probate.
Yes.
So the goal, we should get them all in the trust.
Get them in the trust if you can.
Yeah, okay.
And there is a special form of probate called voluntary administration that is just for estates that have $25,000 or less in assets, plus a car, but no real estate. So if you manage to get almost everything into the trust, but there's some, minor bank account or something that you didn't get to, a savings account that you forgot about that has $320 in it, that one asset is not going to force your executors to go through a whole complex, costly, elaborate probate process. This was one of the nice things we did in probate reform. We created this special category for small estates. So, there's a way to deal with estates with small amounts of assets or estates where almost everything is non-probate, but there's a few things that are left in probate. So at the very least, get it down under 25,000 and ideally get it as close to 0 as possible.
So that's what you mean by small estate.
25,000 plus a car, but no real estate. That's the maximum size for voluntary administration in Massachusetts. Other questions?
It sounds like not having gone through the process, but from what I've heard from you tonight, that creating a within revocable trust seems like it has so many more benefits than simply a will. Provides privacy and a lot more control. But why do is there a lot more are there more financial implications? I mean, why do most people
So,
probate costs versus.
so setting up a trust and moving your assets into that trust is, it's a bunch of paperwork. Um, it's a little bit of a pain. It makes tax season a little more complicated. It's, there are situations where it makes sense, but it's not the right not the right plan for everybody. I think this is one of those reasons where, talking to a lawyer who's not me, is a really smart thing to do. I should say, this isn't like one of those prime rib dinners where, you know, we try to sell you a timeshare at the end. Uh, I'm a niche lawyer. I'm not the person to. I'm not here to find clients.
You're doing us a favor.
Yes, there are some wonderful colleagues here in the community, and this is why talking to one of them is really helpful, because knowing whether a trust makes sense in a particular situation or if it's just going to add a level of expense and complexity without actually conferring any benefit is something that depends on a particular situation. And you need to sit down with somebody who understands those dynamics and, explain and have a back and forth with them and see what makes sense for a particular situation.
Also incur a lot of inconveniences and expenses during your lifetime versus.
Yes, yes. Yeah, I mean, trust versus estate, it's a nice thing to give to your beneficiaries. It will be easier for them when you're gone, but how much easier and how much harder while you're alive, it's sort of a balancing act, that is really dependent on a particular person or family situation. Yeah.
Did I hear you correctly that the mass estate tax is $2 million per person or $4 million per couple?
Yes. Yeah. Each person gets a $2 million exemption from the mass estate tax.
And then once you go over 2 million though, then you go back, don't you? What's tax over 2, or do you go back to?
Yeah, only what's over 2 gets taxed. Okay. Yeah. And okay.
I'll say one other thing real quickly. Is
Sure.
it still true if you own property out of state, do you have to have ancillary administration? And that's something your executor would.
Yeah. So if you, let's say you owned a vacation home in New Hampshire, if you're a Massachusetts resident, real estate elsewhere is not subject to the Massachusetts estate tax, but you would need to do what's called an ancillary, probate in that other state to pass that property to your heirs.
Unless it's in trust.
Unless it's in trust, yes. Yes.
You said, maybe I misunderstood. You said something about when someone has a will, that they let probate know, that let Mass Health know.
Oh, yeah. It's
Is that every person who
yes.
passes?
Everybody whose estate goes through probate, Mass Health is notified, and there's certain expenses. Basically, if Mass Health paid for a nursing home, and the person had assets that were, that Mass Health couldn't access while they were alive, Mass Health can recoup the amount that they spent on the nursing home care from the estate. So Mass Health becomes a creditor of the estate, and so.
But that wouldn't apply to a trust.
That would not apply to a trust. Mass Health will. It's one reason to use a trust. In fact, Mass Health will only go after probate estates to recoup expenses.
And this was in New York, because my parents had a trust, and I'm pretty sure we
It's depending on how the trust is set up. Sometimes you do have to still go through probate, yes.
Thank you so much.
Thank you all. It's been a pleasure. It's been recorded, so you can watch it later at your convenience. If you suffer from insomnia, I'm here for you.
He's got it secured.
Yes.